fiduciary breach of trust, all right? Breach of fiduciary duty. The gist of this cause of action is that one person should not be permitted to gain an advantage over another as a result of the trust that other person places in him, all right? I.e., judges, lawyer, congressmen, legislators, county board, city attorneys, county attorneys, you name it, all right? Breach of fiduciary duty, okay? Because we're putting some trust in them to perform certain duties, all right? To protect our rights, titles, and interests, tangibles and intangible property, right? Okay, that's after all why men instituted government amongst men, was to protect us, all right? That's the basic fundamental element and why government was created. So let's remember that, which means that anybody acting in that capacity carries a fiduciary duty to protect said rights and to fall within the preview of the preamble, the Constitution, the Federalist Papers. Let's see what else they fall victim to. Well, not really victim to. It's what they're bound to uphold. The Declaration of Independence, so on and so forth, okay? Thus, if the defendant acquires and abuses his influence over the plaintiff, all right, using his alleged pseudo authority, being a government official, and abuses the plaintiff, all right, and plaintiff is thereby injured, the plaintiff has a cause of action for breach of fiduciary duty. That's right. Now, this takes me to an important point. Remember, equity will not perfect an imperfect gift. They made an oath, and you should rightfully accept and acknowledge their oath, because equity will not perfect an imperfect gift, okay? So make sure to do an acknowledgement and acceptance of their oath of office and bind them to it, okay? It's just a one-party contract until you accept and acknowledge it, all right? The term fiduciary comes from Latin for faith. A fiduciary, ergo, a guardian, trustee, or even an attorney. Surprise, surprise. If one in whom others are permitted by law to entrust their faith, all right? So they're taking their oath in good faith with good conscience for good reason. They swear or they affirm. Remember, a prerequisite for taking an oath doesn't actually require the involvement of God or any religious prerequisite, right? It's just their word is their bond that they're going to defend and protect the Constitution to the full faith and credit of their ability. And in order to do so, they have to be learned and knowledgeable too, because remember, there's that maximum of law that says, ignorance of the law excuses no man, for all men are responsible for knowing the contracts they enter into. Bingo. Got them, right? Okay, let's move forward. Is one in whom others are permitted by law to entrust their faith. If that faith is abused to the plaintiff's injury, the cause of action arises. Elements. 1. Existence of trust relationship or influence based upon plaintiff's faith. The plaintiff's faith in defendant must be reasonable, i.e., it must arise from circumstances that would cause a reasonably prudent man or person to believe the defendant owed plaintiff the duty of acting in good faith, obligation, and meeting the obligations of the plaintiff's trust. Okay, when they accepted their paycheck, the first one they ever fucking got, they fell into that category, ladies and gentlemen, and we expect a performance, a flawless performance, although we are willing to forgive them for any mistakes they make after we inform them of their mistakes. If they continue to transgress beyond the bounds of the scope of their authority, that is an egregious action that may cause a man or woman to be aggrieved, and because they're taking a paycheck under false pretenses, it would constitute unjust enrichment, honest services fraud, breach of trust, breach of fiduciary duty, that could lead into a number of other causes of actions. Remember, equity will take over to avoid a multiplicity of suits. Okay, so even though you have a number of causes of action, you don't want to bring them one by one. Bring them all together, and then equity will swoop in and bundle them all up, and we'll get down to the brass taxes. Number 2, breach of the duty or abuse of the trust. And 3, damages to the plaintiff directly caused by the breach of duty or abuse of trust. Now, what trust are we talking about? Ladies and gentlemen, every fucking state has a preamble in its constitution. That is what I would say would consummate the implied trust or the constructive trust, okay? And then in that trust would be the trust indenture, which would be the laws of the trust, which is clearly laid out in the Constitution and the amendments, the Bill of Rights, right? What they are to do, when they are to do it, and at what cost they must do it, right? Okay, so that you can express that trust, and if you can explain that trust and express that trust, ladies and gentlemen, you turn this into a trust relationship with a fiduciary obligation and responsibility to we the people. We are one of the people. We are not persons. We have many persons, but we are not a person. We are people, okay? And these people have been entrusted. In fact, they volunteered, okay, to be servants. They're not slaves. They volunteered for it, and they get paid handsomely for it. So there is no excuse for them not knowing their duties. All right. Comments. There is no fiduciary duty or trust arising from an arm's length agreement. The fact that two persons exchange promises and enter into a contract does not impute to them any obligation to act for the benefit or protection of the other party, nor does it require either of them to disclose facts that the other could have discovered by its own due diligence. A fiduciary duty arises only where one party, either explicitly or implicitly, assumes an obligation of trust and the other assumes an obligation of the trust and the other responsibly repossesses the trust in him. To establish a fiduciary duty, the plaintiff must allege some dependency on the defendant and prove that the defendant undertook to advise, counsel, or protect him. Breach of fiduciary duty may be either intentional or negligent. The difference is in computing the amount of damages. One who intentionally breaches a fiduciary duty may be held responsible for all the plaintiff's damages and possible for punitive damages as well. One who negligently, i.e., not intentionally abuses the duty, may be held liable for only such damages as are consistent with the degree of his negligence. Okay, and I'm not going to talk too much about it, but I'll let you know this right now. There is a default judgment that's about to be ordered for $9,999,999, and the federal judge just sent us word that you're good to go. You submit to us a motion for default judgment, and we will grant it. And based upon the officer's performance to rebut, rebuke, or engage in any of the process, although he may try to appeal it, he has zero grounds to stand on for appeal. He did not respond to anything, therefore he acquiesced to breach of his duty, breach of the trust, and he is 100% liable. What ended up happening was a suit for like $2 million that ended up getting bumped up to $9,999,999.99. Pretty remarkable. And that was done, well, I'm not going to give the details because I don't want to get this judge in trouble, but we were provided some information from people who said, this is what it needs to be, and this is what you're going to do. And we said, who the fuck are we to argue with you when you're actually trying to help us? Right on. We're going to do exactly what you said. And we have followed that so far. Now it's just a matter of a supplemental hearing and then writs of execution, writs of garnishment. Of course, then we will get the judgment. And when we get the judgment, then what we will do is we'll do a UCC1. We'll get them to fill out the 430, the defendant, who's a cop, quote unquote, to fill out the 433A and the 433B for all their business assets and private assets, which he just built a really nice $500,000 house that he's not going to live in much longer. Kiss that motherfucker goodbye. Toodaloo. So, anyway, I'm going to tell you right now, the stuff that I'm telling you guys about, the stuff that I'm preaching and teaching works, all right? If you execute these processes proficiently, and you pay attention to what you're doing, you will fucking prevail. No questions asked. Now, that case was moved into the federal court. There were many people that were involved in it, helping out along the way. I just fill a very, very small, minute piece of it, and I have some other people that I brought in that are just gonna just whoop the shit out of this case at this point. But we're green lighted for $9,999,999.99. We've been given a green light from the federal court. It's a go. All we got to do is complete the process, which is really simple at this point. All the hard work's been done. Now it's just a matter of, like I said, getting the default judgment, then getting a supplemental hearing set up, then going through writs of execution, writs of garnishment, a few other things, and that'll be tidied up in a nice little bow. And then what we do is we can turn around and attach the debtor to the debt, making it a securitized lien. See, people have this misconception that a UCC1 is a lien. It's not a lien. It's a notice of interest and some type of collateral, but it's not a lien until you securitize it. In order to securitize it, you have to have the debtor attached to it. And how do you attach the debtor? You attach the debtor with the judgment. So you tie the judgment to the debtor with the UCC1, and now we've securitized it, and we should be able to, in my studies at least, we should be able to go to any Federal Reserve bank and make them an offer, or they'll make us an offer, maybe for a small cut of the award, where basically we don't have to do any collection at all. We don't have to have the sheriff do any collections. We don't have the marshal do any collections. The bank will say, hey, tell you what, out of $9,999,999, we'll give you $8 million, clean out the door right now. Just give us that fucking judgment. Assign it to us. Remember, it's all about appointments and assignments. Assign it to us. We'll take it from here, Scooter, because they'll monetize the shit out of that. And we'll walk away clean. All right? So, word to the wise, it pays to be knowledgeable. Anyway, conspiracy. This is our next topic, is conspiracy. We just finished up with breach of fiduciary duty, which is what this officer got hit with, and it stuck, ladies and gentlemen. When we didn't do it in a lower state court, although it probably could have been done in a lower state court, it was moved to federal court, and it went through pretty freaking quick, and there were a number of great, brilliant minds that were involved in it, and it really wasn't that tough of a process. Conspiracy. To prevail in an action for civil conspiracy, one must prove two or more persons acted in concert to effect some wrongful result for their individual advantage. Each has to have been seeking an advantage for himself in order to be liable for plaintiff's damages. The act must be either unlawful, willful, or malicious. A broad range of behavior. When pleading a count for conspiracy, one is compelled to also plead at least one other count seeking damages for a wrongful act itself, such as tortious interference with an advantageous business relationship. A count for conspiracy standing alone is without basis. Typically, the plaintiff will sue for one or more other causes of action, then add a count for conspiracy alleging the wrongs were committed in concert by the defendant acting as a co-conspirator. When dealing with your agents and agency, you might want to look at the Monell 1983 lawsuit, okay? And this Monell gal gives a beautiful layout on what is being called the Monell 1983. That was shared with me from the guy from Yale, and he's a brilliant mind. The guy's got a different look at things that's really helping me come around. Now, if we can just get back on the same page, it'd be great. Anyway, elements. 1. Intentional commission of an unlawful act or a lawful act by unlawful means through the combination effort of more than one actor. Acts need not be criminal so long as they are forbidden by civil or criminal law. 2. Each conspiratorial act advances or supports the goal of the conspirators. Any act that does not advance the goal of the conspiracy is not a conspiratorial act. All acts must be in furtherance of the conspiracy. Title 18, 241, 242 ring a bell? All right, 2 or more agents acting in concert against you, violating your unalienable rights while conspiring to, extort you. All right, that's conspiracy. 3, overt act of each conspirator, mere agreement or consent does not suffice. And 4, damages to plaintiffs resulting directly from the conspiracy. The gist of a conspiracy is not conspiracy itself, but the civil wrong accomplished by the conspiracy that results in damages to the plaintiff. There must be, therefore, some independent wrong that would give rise to a separate cause of action if committed by one person. Comments. Civil conspiracy arises from an agreement, confederation, or other combination of 2 or more persons, each of whom must intend some benefit to himself from the wrong that results. The meeting of 2 or more independent minds intent on one purpose. The benefit need not be money or property. It could be advantage over a previously enjoyed circumstance. The benefit proves intent, a requisite element of the tort. If Harry and Bob conspire to destroy Sam's business and Bob does the dirty work, while Harry sits back in his office participating by nothing more than letting Bob use his car, Harry is responsible for every act Bob commits, just as if he were there in person. By Harry's agreement and the overt act of supplying Bob with a car, the law will hold Harry liable for all of Sam's damages, just as if Harry had acted alone. We say that each of the conspirators is jointly and severally liable for damages caused by every act of the other conspirators. The act of one is the act of all. The mafia bosses who orders all hits is responsible for the murder, even though he is nowhere near when the killing occurs. If he furthered the act by promising to pay for the hit, either by money, property, or some other advantage, it is as if he pulled the trigger himself. The same applies in civil conspiracies. A businessman who makes a deal with the officer of his competitor firm to walk out and destroy their employer's business, if he provides financing for the defecting employees to start a new business somewhere else after their walkout destroys his competitor, is liable for civil conspiracy to destroy his competitor, even though his lending the employees money was in itself lawful. All right, let me tell you something about this little conspiracy thing. The whole Congress, legislature, House of Representatives, Senate, all of them are engaged in an egregious conspiracy, so fucking large that people think that it's a conspiracy theory, but actually it's a conspiracy fact. The question is, how much evidence does it really take to prove conspiracy? Now, I've had some people that have been held at gunpoint by the SWAT team for 8 hours just to make sure they didn't make it to court. Because if one of the congressmen, one of the senators didn't make it to court, this man won his case. And his case was monumental. And what they did was they held him at gunpoint at his house, Vietas Arms, by the SWAT team in the community where he was at. And they made sure that he never made it to the courthouse that day. Okay? That is such an egregious action. Okay? This man is severely aggrieved over this because he was 100% correct. The problem is they're never going to let the cat out of the bag. All they wanted to make sure is that he never made it to the courthouse, and then they could dismiss the claim for a frivolous claim for which relief couldn't be granted because the plaintiff didn't show up. When in reality, they knew they were never going to get all 545 members of the government to that courthouse. They would have needed to rent a stadium just to get them all in there, first of all. And secondly, they knew that even if just one of them didn't show up, the man won his case. So they held him at gunpoint for 8 hours. He was standing in his yard yelling at them. By the way, he's a melanated man, making it even worse for him because they shoot melanated people all the fucking time, all right? Now, they allege they had a warrant for his arrest, but none of them were trying to take him to jail. In fact, they just didn't want him to leave his fucking yard, and that was made perfectly known to him. You're not allowed to leave your property. You're under arrest. We're going to take you in. At the end of the business day, when the court was closed, this man said everybody, the helicopters, the SWAT team, everybody just took off like it was a union break. Okay, everybody can go home now. And he knew then exactly what had happened. The conspiracy was so grand, though, that who's ever going to believe him? Where's he going to get his true relief when they're willing to go that far, when they're willing to take it to the extremes of making sure he didn't make it to the courthouse? And he tells this story all the time, and he never wavers from it. I mean, he's very acute in detail when he talks about, Derek, when you play with these people, understand there is a certain point where they will push back, and if you keep pushing, they're not beyond taking tactics that would eliminate the problem, if you know what I mean. So anyway, with that said, next time we come back, we'll be talking about constructive fraud, okay? Constructive fraud. And like I said, the conspiracy that the government, the alleged government, is involved in is so great. When you stand up against it, they're all liable for it. Let's just talk about property taxes for a minute. It can be proven, okay? I have the documentation that proves that nobody owes property tax. Not a fucking single one of us, all right? And the legislator and the Congress and the Bar Association and the judiciary all go along with it. Now, we can bring them all into court, and if one of them doesn't show up, we win. But remember, when you go to expose something that great, that grandioso, expect force to be met with force. They're going to make a way that you can't be there to enforce your claim, all right? You can't free the slaves. You can only free yourself. That's one of these elements and aspects that people have to understand. All you can do is preach and teach and help plant seeds that wake people up so they can stand up. But you're never going to be able to free everybody. If you try and do that and you're persistent about it, they just make your ass disappear. They'll Epstein your ass, they'll Clinton your ass, and you'll disappear. That's what will fucking happen, no matter how right you are. Because they're no different than well, wait a minute. The mafia is more honorable than they are. Okay, they're worse than the fucking mafia. And I can't even say the mafia is that fucking bad. All right? So anyway, with that said, constructive fraud is the next thing that we're going to be talking about. Again, we're dissecting all the elements, how to structure your claim, how to put your pleadings together, making sure that you have all this information. So when you do have a cause for an action, that your claim isn't thrown out for a frivolous claim for which relief cannot be granted because you're missing the elements. You're missing the legs of jurisdiction that grant rise to the court being able to hear the subject matter before it, okay? So when we come back, constructive fraud is the next thing we'll address.